Hello everyone, a very good morning. Welcome to Oliveboard. This is the CAIIB Foundation for the June 2025. And in this series, we are covering all the units module wise from the BRBL paper. And today we have the unit 26 from module D, which is the Sales of Goods Act 1930. So in this unit, we'll be discussing about what is the meaning of goods, then the important terms and conditions, what is a contract of sale of good, what is the meaning of the unpaid seller, the conditions and warranties, everything we are going to cover. So when we talk about the Sale of Goods Act, it extends to the whole of India and it governs the aspects, the general principles and essentials of the contracts which are made in the commercial world. And also the Sales of Good Act is governed by the principles in the Contract Act. So now let us start the session. All right. So a contract of Sale of Goods Act, under which the seller transfers or agrees to transfer the property in goods to the buyer for a price. Now here, if you remember when we were studying about the contract of bailment, there also is the transfer of good, but it is for a specific purpose, and once that purpose has been achieved, the goal has been achieved, the bailee has to return those goods to the bailer. But in the sale, what is happening? The goods are sold, the person, the buyer is paying a price for it, so now the transfer of ownership is done. Transfer of ownership, right? So when the property in the goods is transferred from the seller to the buyer, it is called a sale. There's also a difference between sale and the agreement to sell. Sale is a contract where the parties have already performed their part, the seller have sold and the buyer has purchased. Agreement to sell is where the parties they have yet to perform. So we can say it is something that is going to happen in the future. In the sale, ownership has already been passed, irrespective of whether the goods are delivered or not. And in the agreement to sell, the ownership is yet to pass from the seller after the fulfillment of certain conditions. Now, after the sale, the risk is with the buyer, but in agreement to sell, the risk is still with the seller. It will pass only after the agreement becomes a sale. In the sale, if the seller does not deliver the goods, the buyer can file a suit and demand the specific performance and delivery. In, however, the agreement to sell, if the seller does not deliver the goods, the buyer can only claim the damages in a suit. They cannot demand the delivery because the sale has not yet concluded. If the buyer does not pay for the goods in the case of the sale, then the seller can also claim, file a suit, and demand the price. They also have the right to stop the delivery and they can resell the goods. In the agreement to sell, the seller may not part with the goods until the price has been paid. And in the case he parts with the possession, he can sue for the return of goods for the payment of the price. So these are the main differences between sale and the agreement to sell. Now, when we are talking about goods, goods will include all kinds of movable property, stocks and shares, growing crops, things attached to land. All of these will be under the contract of sale. Buyer, seller, and price, delivery, everything have the same meaning. Future goods means goods that are to be manufactured or produced in the future. Specific goods identified and agreed upon at the time of the contract. All of these terms are there, right? So if we talk about the features of the contract of sale of goods, then it is a bilateral contract. There is a money consideration. It is about the movable property, and it is not necessary that it follows a particular form or format, right? Next, we have the terminologies. What is the meaning of condition and warranty? In every contract of sale of goods, there are certain stipulations, terms and conditions regarding the nature, quality and quantity of the goods. These are known as the condition and warranty. So if the stipulation agreed to between the parties is essential to maintain the purpose of the contract and is of such a nature that if the stipulation is breached, it is violated or not complied with, then a party to the agreement would have the right to treat the contract as repudiated or cancelled. Then such a condition, such a stipulation is known as a condition. So something which is compulsory. Like if I am buying a car from the seller, the car should be functional. The car should have four wheels. The seller cannot sell me the car with three wheels, right? So this is a condition. If it is breached, I will cancel this contract. On the other hand, a stipulation which is collateral to the main purpose of the contract is a warranty. The breach of such stipulation gives rise to a claim for the damages only. The parties cannot reject the goods and treat the contract as repudiated. Warranty. If the car seller is saying that the car is new and it will work without any issues for at least 5 years, so that is a warranty that they're providing. It is only a collateral, it is something which is, we will say, complementary. It is complementary, right? Now again, the conditions and warranties can be expressed or implied. Express conditions and warranties are those which are expressly stated in the contract. Implied are those which the law interprets to imply to every contract. It is given, it is understood that this will be included in the contract. Those are implied. They need not be stated vocally or otherwise, right? So implied condition on the seller, they have the right to sell the goods. They will have the right to sell the goods at the time when the ownership is to pass to the buyer, right? Then what are these implied conditions? First is the title of the seller. For example, a person buys a second hand car from any other person and they pay for it, and police takes away the car saying that it was a stolen one. Then the person who had bought the car can recover the price from the second person, as they have violated the implied condition. The implied condition is that the car, the person who is selling the car should be the legal owner, or they should have the title to the ownership of the car. If violated, obviously the buyer can claim their price, recover their price. Second condition is sale of goods by the description. The goods should correspond with the description. For example, if A sells certain furniture to B by describing them that they are antique, they are of the 17th century, later on that person B discovers that those furniture are not of the 17th century, again the person A can reject the good and claim back the price. It should meet the description. Then third is sale by sample. For example, the bulk shall correspond with the sample in quality. The buyer shall have the opportunity to compare the bulk with the sample. It should be free from any defects, right? For example, if A wants to buy rubber material for a certain length and width, B shows a sample to A. A approves the sample, but when the material is delivered, it is delivered with a variation. Again, A can reject the goods as the goods do not correspond with the sample in the quality. Alright. Then sale is by sample as well as description. The goods must correspond not only to the sample but also to the description that is given, right? Quiet possession, that the buyer shall have and enjoy the quiet possession. Once the buyer has paid for the goods, the seller now cannot interfere. The contract has been completed, the sale has been completed, the seller now cannot interfere. The buyer can use the good as and how, in whatever manner they like. Then we have goods are to be free from any charge or encumbrance. This means that they should not be faulty, that the buyer can assume that the goods that are being sold to them would be his absolute property, and no one could claim any right over the goods in the future if they are paying the price. Then the seventh is quality or fitness of the goods for a particular purpose. This means that if the buyer discloses to the seller that the purpose for which he wants the goods and he relies on the seller's skill and judgment. For example, if I want to purchase a fridge and that fridge should be having such capacity that it can serve at least 8 members of the family, then the seller should sell only that fridge to me, right? So it is the responsibility of the seller to supply then in such case. So this is an implied condition. And final is the caveat emptor, which means buyer beware. It is a warning. According to the doctrine of caveat emptor, the person who buys the goods must keep his eyes open, his mind active, and they should be cautious while buying the goods. They must examine the goods thoroughly. Later on, if the goods do not serve their purpose, or they depend upon their own judgment and they make a bad choice, then they cannot blame the seller for selling such goods, right? So the caveat emptor means before making the final purchase, the buyer should make sure that the goods are as per their requirement. Then we have the case of the unpaid seller. The unpaid seller. The seller of the goods is deemed to be an unpaid seller when the whole price has not been paid or it has not been tendered, or when the payment for the goods received in the form of check or other negotiable instrument and it is dishonored. Then it is known as the unpaid seller. Now, here the seller can be an agent of the seller also, a consignor or the agent to whom the bill of lading has been endorsed, right? So, if the buyer they agree to the contract of sale but they are not paying the seller, or they're paying only the half amount, or they've paid through a check and it has been dishonored, then the unpaid seller clause arises. There are certain rights that the unpaid seller has against the goods and against the buyer personally. So what are these rights? Against the goods, the rights of the unpaid seller: when the property in the goods have been passed, when the seller has delivered the goods to the buyer, then they have the right to create a lane, a stoppage in transit, or resale delivery. Or when the property is not yet passed, it is still in the possession of the seller, they can withhold the transit or they can stoppage. These are the rights against the goods. The unpaid seller also have rights against the buyer personally. They can file a suit for the price, they can file the suit for the damages, they can also repudiate or cancel the contract, and they can suit for interest, right? So there are certain rights which are available to the unpaid seller whether the property in the goods has passed to the buyer or not. They can create a lien on the goods for the price while he's still in possession. In case the buyer has gone insolvent, they have declared themselves bankrupt in the court, then the seller has the right of stopping the goods in transit, and they also have the right to resale. Resale, right? So these are the rights which are available. So when an unpaid seller has made, let's say, part delivery of the goods, then they may exercise his right of lien on the balance goods, on the goods that are still remaining. All right. Then the duration of the transit, how the stoppage in transit is affected, then the unpaid seller's right against the buyer personally. All of these things are there. So that is all from this unit. We have completed the contract of sale, which is the unit 26 of our module D. And if you want to study all of these units thoroughly and in detail, you can join the CAIIB Super Elite Plan, which is the all-in-one plan. You will get all the courses under the Super Elite Plan. So live classes, mock tests, notes, And you'll also get the special sessions on the previous cycle papers, doubt clearing sessions, downloadable class PDFs, and everything. You can use the code VDAY to avail 49% off on your subscription. This is the Valentine's Day special, which ends today. So make sure that you join the course and you start your preparation. You can also download the PDF of this session from the link which is given in the description box, and all the other information is also there. So thank you so much for attending. Make sure that you like the video, share it with your fellow aspirants, and subscribe to the channel so that you do not miss any of the updates. I will see you again in the next session with the next unit. Till then, all the best and thank you.